Well, hi there. Today's lecture is going to be on the history and philosophy of the American legal system. So I know this sounds like an incredibly boring topic, but actually I hope it will be quite informative, and there's some interesting little nuggets of stuff that I can give you about the philosophy of the American legal system. It's things that we just don't think about every day, but when you put it all into context, you're like, huh, that's why we do that. Okay, that makes sense. All right, so let's check out the first slide. Okay, what am I talking about whenever I say the history of the American legal system? Well, for those of you who have been in the legal program for a long time, you know that our legal system was heavily influenced by the laws of England. I mean, think about it. These people came over here on the Santa Maria, the Pinta. I'm not sure. It's been a long time since I've been in history class. However, I do know that there were some people from England. They came over. I believe they were called the Pilgrims. They came over, and of course, that is the law that they were familiar with. Now, of course, they didn't like it because ultimately there was a revolution, you may recall from your history class. But there were some things that they were comfortable with, that they brought with them, and those things they incorporated into our current legal system. There were two controlling bodies in England at the time that our country was being established, and it was the King and it was the Church of England. So, the Church of England being a church and the King being a monarch, it isn't exactly what we adopted, but those things, those concepts, those fundamental processes, those ideas made their way into our legal system. So how did that work? Well, so England had this sort of dual court system. So we have to kind of understand that before we can figure out what did we take from that. For English commoners, there were only specific types of actions which could be brought before the court. Now, I'm not talking about the people, the royalty, the lords. I wasn't talking about any of that. These are English commoners. So you could go to the King's Court of Common Pleas. This may be asked on the certified paralegal examination. This was known as the law court. So when you think of the king, think he lays down the law. They decided cases very rigidly, and I always think of the Queen of Hearts. Off with her head! Okay? They applied the law very rigidly and very strictly. They wanted things to be in technical compliance with the law. Look, if you stole some bread, you're going to go to jail for 25 years. I don't care why you were stealing the bread. I don't care about any of that. The law says if you steal bread, you're going to jail for 25 years, or I need to cut your head off or something. That was strict compliance. That was what happened in the King's Court of Common Pleas. So the way I remember that is I think of the king, I think of off with your head. And there's no time to sort of defend yourself or to say, but really, can't you just look at this from, the whole story, the whole context to understand why I may have stolen the bread? That's where the Court of Chancery comes in. This was developed to address those cases in which relief was not found in the law court, but fairness and equity demanded that some kind of relief be granted. Okay, so you go to the law court, there's no law against what you've done, or there's no law that's established that can really make somebody happy. Or it just wasn't appropriate for the law court. You may find yourself in the Court of Chancery, and you might be a little bit happier that you found yourself in the Court of Chancery because it was based on fairness and equity. This is where they would look at, okay, so sir, why did you steal that bread? Oh, your child was starving, and you thought you were allowed to have the bread. You thought that the baker had thrown it out because you found it in the trash behind the bakery. Okay, so you didn't think that you were stealing it. You thought you were just taking what had been discarded and it no longer belonged to anybody. Okay, that makes sense. That's more of the type of thing that was hoped to have happened in what's called the Court of Chancery. And that was actually staffed by high-ranking members of the clergy or the church. So those were those dual systems. You had the King's Court of Common Pleas, which was very rigid and very strict, and then you have the Court of Chancery, which was run by the church, which was had a little bit more of that touchy-feely. And again, remember, this is England a long time ago, so there really wasn't much touchy-feely and happiness going on. But in comparison to the King's Court, that's how it was. So we brought some of those fundamental ideas over here with us to the United States when we were founding our country. Now, laws are based not just because somebody made them up. Human beings, as long as we've been on this planet, we have ideas, okay? Well, some of the ideas, there are 4 main ideas that our founding fathers said, you know what, I like that. I think that's good. I think that when we make laws, when we design our country, we want to keep in mind these 4 philosophies. They were natural law, legal positivism, sociological jurisprudence, and legal realism. We're going to go through each one of them. First, natural law. Okay, natural law says basically the individual has the right to make personal choices. I love that, right? Hey, I can make personal choices. Okay, that sounds a lot like the United States. That sounds like freedom. However, my choices cannot interfere with another person's right to make personal choices. And our modern day example is abortion. You can use the natural law argument to go either anti-abortion or pro-abortion, pro-choice. You can use this argument. Let's look at it from supporting the abortion standpoint. Okay, so I'm somebody, I want to make an individual choice. Okay, so let's pretend I make the choice to have an abortion. Well, somebody using the natural law argument can say, well, yeah, you're perfectly fine to make that choice. But what about the baby's choice? The baby doesn't have a choice. So you're making a choice, but it's interfering with another person's right to make a choice. And then that comes into the whole situation of, okay, when is a fetus actually a baby? When is it a person? Etc., etc. That's where that sort of argument comes in. And of course, the other side is, look, you can't tell me, anti-abortion person, what choice that I can make for my own body. I'm pro-choice. I want to make a choice for myself. I want to choose to have the abortion or not to have the abortion. And so the argument really boils down to is, at some point, does that fetus, does that unborn child, when does that person become a person that has a right to make personal choices? Okay, so hopefully that can help you understand and fit some of these things into that context of where the arguments are based. The next one that our founding fathers really liked, and they use a combination of all of these, is something called legal positivism. This is where we're saying there's an institutional rule of law. Institutional meaning like the government, and then there's morality. Okay, where do people get their morals? Okay. People get their morals from their religion, from their parents, from their upbringing, from the society in which they live. That's where they get their morals. That's just immoral. Something that's immoral might not necessarily be illegal, because the law doesn't have the ability to create laws that address each and every single situation, and I don't think we would want that. But in legal positivism, it says, look, you have to follow the institutional rule of law. That's all we have. We've made the law. You need to follow the law. You can't go outside of the law because you feel like the result is going to be immoral in some way. And that's where we get that phrase, hard cases make bad law. Here's an example. We have a fundamental right against an illegal search and seizure. Okay? It's the 4th Amendment. We have that fundamental right. Well, let's say I'm a child molester. I'm the worst of the worst. People have been looking for me for years. And then someday they happen across all kinds of videotapes. I go to court. And there's a motion by my defense counsel to exclude the videotapes because they were illegally seized pursuant to an illegal search by the police. Okay? Now the judge has to make a decision. Legal positivism says, judge, you need to throw out that case. You need to exclude that evidence because this person, our Constitution says, has a fundamental right against an illegal search and seizure. You cannot allow the police to have done what they did. But what's going to happen if the judge throws out that case, my friends? Child molesters are going to be out on the street. That's a hard case. And if the judge says that that search, which was clearly illegal, if the judge says it was a legal search because the judge doesn't want me back out on the street, that's a hard case that made a bad law. Because you know what? Now that he let the police slide on my case, the precedent is going to be established, and they're going to be able to slide on the next case and the next case and the next case. And you know what? Eventually, there's going to be no more Fourth Amendment. That is what they mean by hard cases make bad law. That's what legal positivism is. It says follow the law, even if you don't like it. All right, sociological jurisprudence. This one is fascinating. Our modern day examples, we are so full in the last 10, 15, 20 years of sociological jurisprudence happening in our society. It's fascinating. The legalization of the marijuana and gay marriage are two great examples of how the law eventually catches up with society. Okay, our society has been saying for a long time, whether you agree with it or not, that the legalization of marijuana should happen and that gay marriage is okay. All right? So whether you agree with it or not, it doesn't matter. Okay? Because our society has been moving in those directions. Because of that, eventually the laws catch up with it. So that's where sociological jurisprudence promotes society's values as the measuring stick for right and wrong. So is it right or wrong? They're looking at society, what's happening today. It evaluates a legal rule by looking at its social effect, and it's seen as a tool for social engineering. Back in the 80s, it was still okay to rape your wife. That may be shocking to some of you. But through domestic violence, education, other domestic violence advocates, you will find that the law eventually caught up. It outlawed things like marital rape. Domestic violence laws became stricter. And in fact, because there was a movement and the law caught on I didn't think it caught on that quickly, but it caught on quickly enough that the law sort of started steering us in that direction. Drunk driving. Everybody was driving drunk. Nobody cared. Nobody thought it was an issue. But then we had advocate groups like Mothers Against Drunk Driving, Students Against Drunk Driving, and the laws became very strict. And then the law sort of changed society. Now we all need a designated driver, right? That's sociological jurisprudence. Then the last one is legal realism. Okay, this is where we get that reasonable person standard from. So this philosophy determines what reasonable people would do in a given situation and then sanctions that conduct. Look, if a reasonable person would look at a situation a certain way, then generally the law is going to be developed to reflect what that reasonable person would think was okay or would do in a given situation. So that's being real, okay? That's the legal realism. Well, I hope you've enjoyed this lecture. I get very passionate about some of these ideas because I think it is so fascinating. I hope you have a great day. And if you have any questions, again, don't ever forget, you can always contact me.